Welcome to In the Clouds. Today, we'll be discussing all things legal and regulatory related to digital assets. The talk show brings together industry experts within the cryptocurrency and blockchain space to brainstorm the past, the present, and the future of this new world. I am your host, Shrez Ahmed, and it's my pleasure to introduce you to our guests today. Florian Ducommun, partner at Bonnard Lawson, expert in all things legal regarding digital assets in the Swiss and wider ecosystems. And Nicolas Masella, legal manager of Storm Partners, the all-in-one cryptocurrency and blockchain solution provider. All right, so let's dive straight in and to one of the most trending topics actually at the moment, the new Swiss DLT law. A lot has been spoken actually about this. It's a very weighted topic as well. Digital securities. We've heard the news from SIX come out most recently. What are your initial thoughts? I mean, Florian, maybe you'd like to give some initial thoughts to this new DLT law that has come into place, and then we can go with it from there.
Yeah, thank you very much. I think there's three main innovations with this DLT Act. The first one is of course, tokenization of securities, tokenization of assets. It's not only traditional shares or participation certificates, but it's also all type of utility token, license, rights. So it opens a wide horizon of opportunities for tokenization. And the main innovation is that when you are tokenizing your assets, you can transfer them using the blockchain. Even if in the law you needed a written form, you can now use the blockchain as a written form. So that's the first main innovation of this DLT Act. Second one is the DLT infrastructure license. DLT infrastructure license is really game-changing in the way that you can have a settlement using the blockchain for exchanges or trading venues. So basically you can couple custody, the deposit of the tokens, and the settlement within one license. And basically that changes the game. Why? Because now everybody can enter into the trading venue without being a regulated player. And so you are cutting the intermediaries, the brokers, and the banks of this world, and you can enter directly into the market trading on your own. And the third innovation is the fact that now digital assets, while crypto assets are and can be segregated from a bankruptcy. So the same as shares or values deposited in a custodian in a bank, you can then take them out of the bankruptcy, which give a lot of more security to the clients and more security in general to the Swiss legal environment.
Wow. Okay. And those are three, fantastic points there. You probably covered most of them, but what new opportunities, and maybe Nicolas, you can comment on this, has this opened up for not only, let's say, the Swiss ecosystem, but maybe even also, let's say, other governments that might be wanting to put in place a framework of the likes?
So let's start from the Swiss ecosystem itself, in my opinion. So the big possibility is that basically Switzerland could be the first country to have regulated security token exchanges in which you can, of course, trade security tokens, but also other crypto assets. So it will be, let's say, the first general purpose trading venue, including security tokens and Bitcoin or Ethereum's all in one. Of course, there has been many attempts to create such a structure in the past years, and never happened, basically in other jurisdictions. So the fact that Switzerland is the first country to put in place a regulation that enables to do so will be a significant, let's say, competitive advantage in these terms. What can influence, like, let's say, other governments or other jurisdictions to follow this example if, of course, it's become successful, they also would like to attract these same business opportunities. We have already seen that the European Union has two different proposals on regulating crypto assets, the famous MiCA proposals, but also DLT market infrastructure themselves, which is, let's say, a less known proposal, but interesting as well. The point is that Switzerland has a competitive advantage as a jurisdiction itself, also in being more innovative, more fast, and having, let's say, significant more knowledge about blockchain and crypto assets than at the current point in time other jurisdictions in the world.
Yeah, great. And we'll touch upon that a little bit later as well. But I mean, for, let's say, personally for myself, I mean, getting into this space at quite some time ago, I was always looking at tokenization, like the ability to have an Amazon, right? An Amazon of kind of products and services, but in this type of situation, assets and investment opportunities, whereby you could just find a solar panel farm or the Mona Lisa or something, and click in a few clicks, have a diversified portfolio of assets, and then be like, ding, and then with, I don't know, 10 euros, 100 euros, you have a diversified portfolio. I mean, are we far from something like this? I mean, like STX, Taurus with TDX. I mean, do you think we're ever going to be able to get to a point where it's kind of as user-friendly as some of, let's say, the applications we see out there today? When do you see we'll get to a point where, I'd say, the general public will be able to use it seamlessly? Maybe Florian?
Yeah, I think one of the key elements of this new act is that basically the capital market as it is structured is changing, and the access to the capital market for individuals to invest is made much easier than it was in the past without, as I said, intermediaries. And also for companies, it's quite the road is already paved for tokenizing shares. So you as a company, you can tokenize your shares, and with this new DLT infrastructure, you can list them on trading venues and raise capital using these trading venues. So basically, yes, I think now as a startup, as a company, that will open new avenues for getting access to the capital markets. And for the consumers, for the small investors, they can decide with applications in which company they want to invest, and that's the new innovation that we're going to see in the future. So I think this is really important to understand, that there's been a shift from the way the capital market is structured in a very centralized way, with a clearing and settlement which is done on the side, and a central depository which is on the other side. And now we have everything in one place, and with the power of an app, you can indeed invest your money in which coin you like. So I think that's something that is going to be the finance of tomorrow. Yeah.
Wonderful, thank you.
And just to answer quickly your last question, yes, in my opinion, we are not far. We are not far from a kind of platform in which you can invest in different asset classes, including entrepreneurial initiatives with their security tokens. And of course, as Florian was saying, this opens up way new opportunities for the capital market itself, for the entrepreneurs that are looking for funding for their initiatives, but also for the, let's say, retail investors that desire to diversify their portfolio, or also to invest in, let's say, different things from the large companies listed on the stock market.
Wonderful. And so you're both mentioning that, like, Switzerland is quite at the forefront of the tokenization of assets. Are there any other jurisdictions that you have your eyes on at the moment that are, let's say, looking to build something similar, or are on the verge of bringing out something similar? You mentioned the European Union, but any others?
Yeah, so of course we have to make a clarification. European Union is in some sense a jurisdiction, yes and no, let's say. So it is a union of different countries. It has its own law, but then all the 27 member states has also their own national law. If we look at European Union, we can also include Liechtenstein, which is a member of the European Economic Area, and still European regulations apply, but they were able to develop their own framework for blockchain regulation, which in my opinion is one of the most interesting existing on the planet.
Yeah, thank you. Florian, any comments to that? Any jurisdiction that you're seeing that might kind of have certain frameworks in the future to be maybe not a competitor to Switzerland, but have other advantages from this side with regards to the tokenization of assets?
Yeah, I think the Swiss approach is unique in the sense that it's not enacting this law to add regulatory layer, but to bring innovation to a next level. And I don't see any other jurisdiction with a financial market infrastructure using blockchain now. It's for me, that's the innovative framework that Switzerland is bringing to the world. There are indeed DLT or blockchain acts in Malta, they are in Liechtenstein, they are now in Ukraine is potentially enacting a new act on blockchain. But I think it's more for the purpose of regulating these assets as financial instruments than pushing new ways of being able to use blockchain technology as it is for the Swiss Financial Market Act, because it's changing it's really a new financial market infrastructure that Switzerland has created.
Here we're talking about tokenization of assets, so security tokens, or as Finma mentioned, them being asset tokens, right? And so Switzerland was the first to bring out a classification of tokens, actually worldwide, with not only asset tokens, but also utility and payment tokens. Just want to take some time to discuss a little bit about these two as well, right? Because here you're mentioning that Switzerland is the first from the tokenization side of assets, but also actually was a front runner in let's say the earlier stage of utility and payment tokens as well. So it's true that this classification of tokens is still, let's say now, it's kind of gone and passed, and now people are quite used to it. But how do these tokens now affect how things are moving forward in the future? And even, I would say, let's say the regulated approach for some of these tokens, now that a lot of the time they're not considered securities. So how is, let's say, the movement of these tokens cross-jurisdictionally happening, etc.? Is there an impact on other jurisdictions if they're classified in Switzerland abroad as well, or not? How do you see the movements between the two? Maybe Nico, you answer.
Okay, that's a really difficult question, let's say. I wouldn't say that there is an impact like on how a token is classified in a jurisdiction to another jurisdiction, because financial market law is national, and in the end, a financial market authority will apply their own law. In my opinion, the let's say more clear example is the United States. The United States has a really, let's say, conservative approach towards token issuers. And in particular, they apply the so-called O-way test, which is based on a decision of the Supreme Court of the United States, but 70 years ago, basically. They apply this test because it's a common law jurisdiction, so it's how it works. And they decide if the token is a security or not. The fact that the token is not considered a security in Switzerland or elsewhere in the world, in my opinion, is not particularly relevant for the SEC. It could be relevant in the sense that the issuer is in good faith. If obtained a declaration from other financial markets authority concerning the qualification of his own token. But more than that, the problem with also with the fact that blockchain and the internet itself is worldwide, while regulations are nationals. And so when you go in a jurisdiction and you offer your services or your products, in particular if they are financial products, to the citizens of that jurisdiction, the courts and the authorities of that jurisdiction will tell you, is our law that applies? And yeah, this is also an issue. And in the end, you have to face it, and you have to protect your clients also with regard to this issue.
Okay, I understand. And so here, related to Switzerland, you're talking more specifically about like a no action letter that could be given from FINMA. So do you believe doing such a thing is still relevant, even if it could be only, let's say, valid in Switzerland? Or
Maybe I can answer this one. So I think to step a little bit back, I tend to agree it's a cross-border approach. But if you issue the coin from Switzerland using a foundation or even a company issuing a utility token, and you get this no action letter from the regulator in Switzerland confirming actually that it will qualify it as a utility or a payment token, then that will be helpful for registering, listing that on exchanges, on Kraken, on Binance, on Bitfinex, because you will be able to show that your token has been qualified as such. So then potentially it will be qualified differently by other regulators, but you can still list them in exchanges which will give value to your token. So I think that still makes sense to do it. That's the first reason. And we saw also in the United States with Ethereum, with to some extent Ripple, that the fact that the token has been issued from a Swiss foundation or Swiss entity had an impact also on the analysis from the regulator. So I think it's not black or white. The token can be qualified differently by other regulators, but the fact that you issue it from Switzerland and that's confirmed by the regulator by a no action letter that it should be qualified as such will give some legal certainty to some extent to the whole project. And that's why I always advise my client to go and get this no action letter. It takes some time, but for service projects, what is it to have 3 or 4 months to get this letter that will open up the doors then to other exchanges and to be able to bring the project to a next level.
Yeah, I understand. Yeah, building that solid structure is quite important. And
just to conclude, yeah, I really agree with Florian. I think the most important things to say is that, as he said, is not black or white. So yes, I completely agree. And also other authorities, in particular, I was making the example of the United States because I feel in this moment is the jurisdiction that is posing more problems and also as a more, let's say, different legal system from our type of legal system, also with regard to the qualification of the tokens. And so, of course, all these, let's say, help, but it's also true that I cannot tell the client, okay, you get this letter and then you are fine everywhere in the world, because it's not black or white. So you have to really assess the potential outcomes and problems with regard to different jurisdictions.
Okay, great. And you both touched upon something very interesting, and we passed by it quite quickly, with the ability of foundations, associations, companies. So these token offerings happen through different entities. I mean, and this I think quite a complex and maybe even interesting one is why would a project decide to either found a company, a foundation, association, maybe even a mix of two? Maybe Florian, you can give us some context here.
Yeah, I think for me the reason for incorporating a foundation or companies is mostly the nature of the project. Is the project going to issue a native token to have a blockchain protocol in place? In this case, it makes sense to have the foundation to ensure a proper governance of the protocol, governance of the tokenomics around the project, and it's not per se the foundation that will issue the token. It will be the protocol that will issue the token, and then the foundation that will safeguard finally the nature of the project. So non-profit structure, as it was done for Ethereum, for Tezos, is made really for me for open source protocols. And we had, before even all the blockchain foundations, we had open source foundations for Mozilla, for Creative Commons, so other type of non-profits. And this model was used already before for open source software, and blockchain is one of them. And the company, if the project is let's say to issue an ERC20 token without native aspect of the token, but just to have a pre-sale of products and services. It's a commercial business, but you just pre-sale through tokens your services. Then you can account that, in your P&L and have some reserve for future services or products. So it makes sense to issue it, to incorporate a commercial entity and then to issue the tokens through a commercial entity. But it will really depend on the nature of the project. And one interesting model that has not been now really put in place is also the cooperative. So a cooperative cannot per se tokenize the shares because there's no shares, but it could issue also a utility token to use, the products or the services that the cooperative will bring, and all the revenues will be reinvested into the project. So I think this is also a model that we worked on back in 2018, and then suddenly, with the crypto winter that went down and it never came out of the drawers. But I think this is a model that could be interesting also. So you don't have only the limited company or the foundation, you could also have a type of in between with the cooperative. Yeah.
Definitely an interesting model.
Yeah.
Also, an association could be a model for fully decentralized organizations. But in the end, as also Florian said, the nature of the project is really the key here to understand the appropriate legal structure. And the point is that maybe people that look at like the crypto space, they see tokens, coins, and it's a bit all the same thing to some extent. In the end, it's not true. You have really to see the issuer, what they do, what's their project, and they are really different. A coin or a token is just a technological instrument to access something. Then the something is what you should look into.
Yeah, I see. And we actually recently saw in the news that one of the token issuers created an association and then wanted to essentially liquidate the association to create ultimate decentralized capacity. I mean, what do you think about that?
So, they basically, it was a decentralized project. They created an association to manage in the first place, let's say, the funds, the development of the project. And then at some point they said, okay, but we want to be fully decentralized. And so they dissolved the association. Now there is no legal entity related to the project. I think, to be honest, that is a regulatory gap that at some point will be faced by the regulator, the regulators of the world, basically, because we are in a, like the technology gives you the possibility to create some kind of human society, human association that exists and coordinate the behavior of different people, but they do not exist legally, or they do not have a correspondence as a legal entity. And this is a regulatory gap.
No, I see. Wow, very intriguing first half here. We will, let's say, put a little bit of a break on things here, and we will be back very shortly with part 2, where we'll explore decentralized finance, investing in this space, and the various types of exchanges and the regulatory implications about that. So stay tuned, and we'll talk to you in a bit. Thank you.